There are, broadly speaking, 6 types of investments that you will see in the world of litigation finance. First off, there is going to be single case commercial litigation funding. And this is when there's a single case, one or more plaintiffs against a defendant for very related issues, right? One cause, well, I was going to say cause of action, but that's not true, right? So it's one lawsuit, maybe with many causes of action. And usually it's non-recourse funding for legal fees, litigation expenses, working capital, etc. And these case types really run the great gamut. They can go from breach of contract to breach of fiduciary duty, shareholder disputes, intellectual property, theft of trade secrets, non-competes, really, you name it. And because of the nature of commercial litigation, usually financing is pretty stage agnostic. So they'll just look at the case and figure out if they want to fund it. The next overarching type of litigation finance you're going to find is in portfolios and complex financing. This is where there is funding of a portfolio of cases, and they are cross-collateralized. We can talk of mass torts, class actions, or if you have one particularly litigious client who has a lot of cases and maybe they want to get financing, so you could cross-collateralize all of their cases. And this type of financing will usually bring up custom financing solutions because they're going to have to address the complex needs of corporations and law firms. The next type of case that can be financed is international arbitration. Now here, different companies have different preferences. Some companies are happy to fund exit type cases, which is investor cases. Others prefer not to because there are issues regarding to foreign enforcement and going up against foreign governments. But certainly international commercial arbitration is definitely something. And I wanted to also mention, since we're on the topic of arbitration, arbitrations get financed just as well as cases. So don't think that because it's an arbitration, it won't get financed. Then there is funding for intellectual property rights, and this is to finance plaintiffs that are protecting their intellectual property. And financing helps to unlock capital that could be used to pursue assertion campaigns or can be reinvested into the operations of the company, so that while there is dispute over the IP, that IP can still be monetized and developed and does not create a pause button for everything. Next, you can encounter law firm funding, and this is very common. This is where a law firm will go to a financing company and say, look, I have a portfolio of X cases. I value them at X number of dollars. I would like cash to engage in these cases. I either want to grow the caseload, I want to just work on these cases, I want to grow my firm, I want to have personnel, I want to have staff, I want to add employees. Whatever it is, law firm funding is a really effective way to leverage the collateral that is the portfolio without having to resort to personal guarantees. Because when the portfolio is collateralized, you will certainly find companies that do not require personal guarantees. LexShares is such a company, and we would collateralize the portfolio and only the portfolio. And then finally, litigation finance can be sought to do post-settlement monetization. And that is when there is a settlement in place or when a judgment has been issued, and either the money is going to be slow to be paid out for legitimate reasons, or slow to be paid out for more illegitimate reasons, in the sense of the defendant is refusing to do so, and they're going to force an enforcement action against them. And a litigation finance agreement would allow to ease collection pressures, alleviate cash flow concerns, and it helps claimants and law firms expedite payment of awards and fees.